Yep. Good evening, everybody. Good evening, everybody. Excuse the jerry-rigged gavels for tonight's exercise, but we are somewhat limited by what we have to whatever common kitchen is here. I want to thank everybody for coming out on a very hot evening. I hope everybody has had a lovely day enjoying all that Hull has to offer. And what I'm here to do is call this meeting to order. And my name is Richard Hennessy. I'm an attorney. I'm also the chair of Hull's Zoning Board of Appeals. To my left is Phil Ballone, who's an alternate member. Further left is Tony May, who is a voting member. To my right is Ed Parsons, voting member. And further to my right is Rebecca Rogers, also an alternate. And then as an added bonus, we have counsel Chris Kenny, correct? Yes. Who has been retained to represent the Board of Appeals as it relates to this hearing. So again, we got a packed house. We're on TV, so everybody get excited to look their best for all who's watching from beyond this room. And essentially what we want to do is come back to this. We were here on July 21st, 2026, where there was a decision agreed to by counsel for both the property owner as well as the planning board to continue this matter until tonight so that we could retain counsel and get all our ducks in a row. Admittedly, a lot of us are here, at least me and I think everybody else at this table. This is the first time that the Board of Appeals has had to address a site plan review decision on appeal. Okay, and what Renee, our administrator, is handwritten the agenda for tonight. So essentially, we're here today. It's a little after 7 p.m. for the continuation of a public hearing on a petition filed by the Point Nantasket Realty LLC regarding property at 839, 843, and 845 Nantasket Avenue, map 12, lots 106, 108, 109, 160, Hull, Massachusetts.
110. Sorry.
Pardon? 110, which is stated in the application, seeks to review a decision by the Town of Hull Planning Board to deny a request for site plan review under section 410-4.1C of the Hull Zoning Code. I want to make sure I'm getting this thing right. My apologies. Hull Zoning Code and MGL Chapter 40A, Section 8, and to appeal the decision of the building commissioner in denying the building permit under Article 1, Section 410-1, C1. A building permit cannot be issued for projects which site plan review approval has not been issued. So that is why we're here tonight. And I want to explain to the audience how tonight is going to work. So forgive me for being overly chatty at the outset of this, because what we really have here is the property owner as well as counsel representing the planning board here who will make their pitch as to their respective positions. What I wanted to get out ahead of is the public interest in this. Obviously, this room is packed with folks who have what I believe to probably be very strong feelings one way or the other as it relates to this project. We've also received, as it relates to the Board of Appeals, several letters from Hull citizens with their opinions about how tonight should go. And I say this with peace and love and out of all the respect for the world. This is not an ordinary zoning board hearing tonight where the order of business includes public comment. So what I need to inform everybody who's not tied to either the project or the planning board is there is no public comment tonight. So instead, we are here on a it's hard to sort of contemplate given the noise that's been surrounding this project. We are here as it relates to the planning board on a very narrow issue. So what we have is we have a planning board decision that was issued by the planning board back on, I think, May 19 of 2026. we also have a record below that went into the planning board making their decision. That is the closed universe that we have for tonight. And the Board of Appeals' role, pursuant to the applicable bylaws that we will all become insanely and intimately familiar with as this night progresses, that is our role, to either make a decision that the planning board's decision is affirmed, meaning that they abided by all applicable zoning bylaws in coming to their decision, or if there's an alternate view of things, meaning we can either affirm or we can also remand it back to the planning board. I don't want this to be a pin in everybody's balloon in terms of how tonight is going to go. But I ask that we make our very best attempt to keep tonight laser focused on what we're here for. It doesn't mean that anybody's opinions beyond the front row of this room have no merit, because certainly they do. But they don't have any role in what the zoning board is to do tonight. Again, as I said, we are limited to, and I don't know, Renee, if you can put up the town website for a second as it relates to this project. This sort of demonstrative aid will sort of hopefully assist everyone in understanding my little opening salvo here, is that to the extent everybody can see on the monitor here, is that we have so very much a full plate of documents for consideration. All of the documents that are below the Nantasket Avenue are part of the petitioner's presentation for tonight, including exhibits and all that kind of stuff. We also have a memo from the attorney representing the planning board, who we've reviewed and considered. These two things by themselves are not evidence as it relates to what we do, but mostly a summation of each side's respective views on this planning board decision. The key issues that are going to be addressed tonight correspond with that top hyperlink that is the planning board record. And in that, it has all of the different things that went into the planning, but like the chronology of the whole process up to the point where the planning board issued their decision on May 19, 2026. So we're not here, and my role here will be to sort of, referee things. We're not here to uncover new things, sensational things, things that draw out some kind of emotional response. We're very much stuck to the record below. To the extent there's any attorney in this room, God bless you all, you get it that on an appeal, you're boxed in by what happened below. You're not here to take new information in, because that just makes it all very muddy. So I hope that is something that everybody can understand and recognize. And how we will play out tonight, once I shut my mouth, is the petitioner through counsel will be allowed to present their arguments, which dovetail with the memo that they've submitted and all these corresponding exhibits. The board, all of us here, are entitled to ask questions of the petitioner. He may have representatives from the project speak. We can do all sorts of things. We can ask them questions, things that will draw out information helpful for our decision. And then once that initial presentation is complete and questions asked, we open the floor up to the planning board through their counsel. Planning board's counsel may have representatives from the planning board here to comment on the information in this site plan decision. The board will then be allowed to ask questions. There is no real back and forth. It's not like a courtroom TV show where attorneys are screaming at each other on either side of the table. I love chaos in the work that I do. I love drama. I love Lifetime movies. This is not the place for that tonight. It's hot enough for everybody to be here in this room with somewhat, limited air conditioning. Pursuant to legal counsel's instructions to us, we will also allow a little bit of like rebuttal. So Attorney Brodsky, on behalf of the petitioner, can sort of, respond to certain things from Attorney Brian Winter on behalf of the planning board, and vice versa. Again, my role is to just sort of keep this thing moving forward so that we're not here all night, and hopefully we come to a conclusion tonight, one way or the other. The board can ask all sorts of questions, but our questions, just like the presentation from both sides, has to be limited and targeted to how this site plan decision came to be. Any additional information, I hesitate to raise my voice or become an ogre, but if things stray from these parameters, you may hear me, bash whatever these things are to sort of restore order. And to the same sense of the public, those who obviously have strong feelings one way or the other, if people get loud and mouthy or aggressive, like, it's nothing personal, but we can't have that tonight just because it doesn't make any sense, and it will disrupt the regular order running of things. So I hope that is agreeable to everybody in this room as we endeavor to sort of go out on this interesting issue that I think is going to be informative and helpful for all parties involved. So absent anything that I've overlooked, and also tonight, for purposes of this vote, for anybody who was here listening to when we were present back on July 21st, myself as chair made a determination that I would be voting on this along with Ed Parsons and Phil Bellone. That would be the two regular members of the Zoning Board of Appeals, and then Phil as an alternate. I've been subsequently instructed that I do not have the power to sort of determine who gets to be on whatever project. So as a result, what we have is the three voting members, of which it's myself, Ed Parsons, and Tony May. I, as the chair, am committed to being impartial as it relates to this project. I have no conflict that would render my ability to sort of ascertain what's going to be presented, as well as the outcome of this, in a manner that would be in any way untoward or biased one way or the other. And I just asked Ed Parsons, what's your position on that? Are you able to?
Exactly what you just said.
Okay. And then I go to Tony May. How are you, sir, as it relates
exactly.
to this? Okay, so everybody is all set. So it will be Tony, myself, and Ed, but that doesn't foreclose Rebecca Rogers or Phil Bellone from asking questions of either side. Because we are a team, and just like we are all a community, I think it makes more sense to have all issues sort of uncovered so that we can make sure whatever happens is done properly within the confines of our charge, and that the result, one way or the other, will be made in a good faith and very objective standard. So with that, counsel, am I okay?
Very well done.
Again, my whole role here is not to get yelled at. I've learned that from my mom, my ex-wife, my current partner. Just don't want to get yelled at. So with that, I'm going to open the floor to the petitioner and welcome Attorney Adam Brodsky.
Chair Hennessy, would you like me to speak at the podium, or would you like me to speak sitting?
I
I
am
understand that we don't have microphones, but you do have microphones for the video.
exactly. I think subject to Hull's delightful TV, and subject to your own, because I'm a mover and a shaker when it comes to my presentations before a court, and I don't like to be fixed because it freaks me out. If you need to move around, absolutely. I don't know if we have. Do we have walking mics aside from this big monstrosity right here?
All I was suggesting is obviously we're going to have a presentation
Yep.
related to the PowerPoint, so I can begin my comments there if that's appropriate. I think there's a microphone there.
It is wireless.
Yes.
Okay.
So,
yeah, it's
would
at
that
your
be-
at
thank
your
you.
preference. And I would the only question is Attorney Brodsky, what we've been present. So prior to tonight, we have what I hope everybody has been able to sort of look at is we have essentially a 20-page appeal document that's prepared by Adam Brodsky and his law firm as it relates to this project. Attached to those are like, I think, 17 or 18 exhibits, which served as the basis for what's going on tonight. Attorney Brodsky, what we've been presented with tonight is sort of a slide deck printout. And rather than question the need for this, given the robust materials that we have before us, please tell me how is this more of a demonstrative aid as it relates to your presentation, or is anything here new and unknown to everybody else aside?
No, this is simply an aid in presenting information that's contained in the record. And I do want to go on record, however, I respectfully disagree with Mr. Kenny's opinion that this appeal is limited to the administrative record. My view of the world is similar to a zoning appeal, which is a de novo review, but I've agreed not to present any additional information in order to speed this process along. So all of this information has been presented to the planning board is common knowledge, and is simply an aid in understanding the record, because if we had to review page by page the hundreds of pages of documents that were presented to the planning board, that would take a long time, and we've committed to being as brief as possible. In fact, it's our hope that we could complete this, at least our portion of this hearing this evening. So it's a desire to speed things along.
Okay, and I'd be remiss to not sort of open it up to Tony or Ed. Do either of you gentlemen have any issue with Attorney Brodsky using this as, for a demonstrative aid / chalk to sort of streamline the process?
I believe that we're here tonight to uphold or disapprove the planning board's finding of that night. I don't believe we're here to go through a whole package again.
Tony?
I think Ed is right. It's to affirm or remain.
Okay, and then,
So if I might, at the appropriate time.
yeah, then the other thing is just I'd open it up to Attorney Winter. Do you have a position one way or the other as to the use of this document?
So, Mr. Chairman, for the record, Ryan Winter, counsel for the board in this matter. So my understanding is that this is essentially a chalk that is duplicative of materials you already have, and based on that understanding, there's nothing new that's being submitted for the record or that the board is being asked to consider. If it were something new, I would object to it, and so based on that stipulation, I don't have an issue with it.
And have you seen this before tonight?
No, I was just handed it earlier today. I haven't seen it in this form. And so I'm basing that on the representation that we all just heard a minute ago, that it's not new information, that it's consolidated information that's already part of the record. And if that's true, I don't have an issue with it, but if it's anything beyond that, then I would object to it, because of course then it would be something the planning board didn't even see.
Got it.
So that's not to suggest that the board can't determine independently what it wants to do with it. That's just my position on the matter.
Okay, and Attorney Brodsky, on behalf of the zoning board, I'm going to allow you to use this PowerPoint slide deck only as it relates to sugaring down the information that is in your appeal memo. And just for the public, you may be seeing things you've not seen before. I will respectfully ask that there be no chatter as it relates to this, because it just will disrupt the whole process. And, oh, I'm sorry. I need to record. Oh, it's recorded here. Should I do this anyways? Okay. My apologies. I have my normal zoning board of appeals hearing helmet on, where we don't normally have TV here. So we're cool because everything's been recorded already. So what I'll say, Attorney Brodsky, is that proceed, and if I happen to, or either Tony or Ed, sense that something is a little bit new or straying, we'll just talk to you about it. But for purposes of efficiency, you can proceed.
Thank you. And again, this serves as a chalk. It's not intended to constitute evidence. And again, happy to address any concerns that may arise during our presentation. And good evening, everyone. Good evening, members of the board. My name is Adam Brodsky. I'm a local land use and environmental lawyer representing the Point Nantasket Realty LLC. I'm here this evening with Chris Reel, Pete Pitroff, and Tom Fleck, who are principals of the LLC, as well as Carlos Scolti, a registered professional engineer with CEC, which is the project engineering firm. This evening, we are planning on having Tom and Pete, as well as Carlos, speak to the board. I'd like to provide an introduction and then turn over the presentation, after which I'll provide concluding remarks with your permission.
Sure.
As you've indicated, just to be clear, there are two appeals here. First is the appeal of denial of site plan review by the planning board. And as Chair Hennessy has also mentioned, there's an appeal of denial of a building permit by the building commissioner, Bartley Kelly. The focus of our comments this evening are going to be on the planning board denial. We obviously need planning board approval in order to obtain a building permit. And in order to demonstrate that we've exhausted our administrative remedies, we had submitted a building permit application to Mr. Kelly some months prior to our submittal to the planning board, and he denied that because we had not secured the approval. So we simply appealed his denial of the building permit, as I said, to exhaust our administrative remedies. It's a procedural issue, not necessarily a substantive issue. If the board determines that the decision of the planning board should be reversed and remands the matter back to the planning board, that will also resolve the building permit appeal.
And not to interrupt you, Attorney Brodsky, but for the folks who are, if they have any confusion about this, it's sort of like a chicken or the egg kind of thing. You can't get a building permit unless you got a site plan review, and you can't get, if you don't have your site plan review, you can't get a building permit. So it's like this weird circular thing that you gotta have one before you get the other. So I hope that makes sense to everybody, and that Attorney Brodsky has correctly framed this as, like, again, site plan decision from the planning board. This is what we're here for tonight. The rest will come out in the wash, so to speak.
And Chair Hennessy, you've alluded to the novelty of this circumstance. I've been doing this for some time. I believe this is the first time I've ever had a planning board deny site plan approval. I've certainly had planning boards grant site plan approval with conditions that my clients have disagreed with, and we've addressed those problems. And this is, in my experience, and I think you've acknowledged this, the first time that I've ever had to deal with a denial of site plan review in the town of Hull. And what may be a little bit confusing here is that site plan approval is not a permitting process. The planning board is not sitting as a permit granting authority. They're simply required to review the project for compliance with the site plan review design guidelines that are set forth in the zoning bylaws at section 4.1D. So it's our position, and I believe borne out by council, is that the planning board under site plan review doesn't act as any zoning authority, doesn't opine regarding zoning compliance. Similarly, has no authority to address building code issues. Those are issues squarely within the jurisdiction of Building Commissioner Kelly. Their job is to review the site plan in compliance with the design guidelines. And I've briefed this, and I'm not going to speak extensively about this in our appeal, but as a matter of black letter law in Massachusetts, under site plan review, the planning board is limited to imposing reasonable terms and conditions. And actually, in our opinion, does not have discretionary power to deny a project which proposes an allowed use. It's very important here. What we're proposing and have proposed is a 9-unit multifamily building which is expressly allowed within the commercial rec C zoning district. Now, The board may remember that when we originally filed our applications, we also filed an application for a special permit because the original design of the project did require zoning relief, and there's no need for me to address that because as the project progressed through the planning board review process, it was changed to eliminate any requirement for zoning relief. And the Board of Appeals will remember that it granted us permission to withdraw that application for a special permit.
That is true.
And so the project fully complies with the zoning bylaws as confirmed by the determination of Building Commissioner Kelly, and I want to stress that. Again, it's our opinion as expressed within our papers, which I hope you have had an opportunity to review, that there's no real question here that the planning board committed procedural errors and that the stated grounds for denial have no factual or legal basis. We're not shy about saying this. This decision was motivated by politics and not
I'm
by...
going to stop you right there. All right, so I'll say the same thing to the planning board, is that your appeal memo opens with this concept of a witch hunt. That's neither here nor there, and it has no bearing on this. So bypass that and go to the meat and potatoes.
Thank you, Chair Hesse. So the follow-up point I was going to make is that the real question for the board is the remedy. I think you've suggested this, but it's our opinion that the Board of Appeals can't itself grant site plan review. And so the remedy here is a remand back to the planning board. However, as we've addressed within our papers, we think that there are certain guardrails that should be imposed upon the remand to the planning board, and I'm happy to address those later on in the process. So with that somewhat brief introduction, I'd like to turn it over to, I believe, Tom, you're going to go first. And our intention here is simply to describe the project and describe how it complies with the design standards so that the board is assured that we had met
Out
our
of the scope.
burden of proof, entitling us to site plan approval.
Do you agree?
It's what he's trying to say is, all right, so to the extent that this individual is going to speak about what he believes to be are the design guidelines, I'm gonna be mindful of again, you're here to tell us why the planning board messed up, and to the extent that it has any bearing on these design guidelines, and for everybody's education and edification, this is 410-4.1D, subsections 1, 2, and that's it, and all sorts of things. So I'll allow you to again track with your appeal memo, and that's all. Nothing
And again,
new,
just to
nothing-
remind the board that one of the grounds for denial was the allegation that we did not present sufficient information to carry our burden of proof.
Yep.
So we need to demonstrate to this board that indeed, not only did we carry that burden of proof, but we actually carried the burden of persuasion and provided all of the required information in order to demonstrate compliance with those standards. And so that's part of our obligation this evening, and we're going to try and, we will satisfy that this evening. Thank you.
Okay. And before this gentleman starts, does anybody on the board have any questions about how we've gone so far? Okay, then continue. And just for the record, just your name.
Yep.
that
Hi, everyone.
kind
My name is Tom Fleck. I'm a principal owner of the property, and I was heavily involved in the process of the planning board approval. I think that what I've been asked to speak about tonight is the process of the design and how we progressed to where we ended up with the design.
I'm sorry to sort of cut you off
That's
real
okay.
fast, but in terms, your testimony tonight relates to your role as a principal, a co-owner of this property. But do you have any professional experience, engineering?
I'm also the builder of record. I'm a licensed unrestricted CSL holder. I would have
Okay,
been
yeah,
the,
so your qualifications you can throw out as
Sure.
well.
I hold an unrestricted CSL, so I can build any commercial property. I have a all the licensing required to do any kind of commercial multifamily work. So I'm the principal, or one of the principals, and also would have been the builder of record for the project.
Thank you.
Yep. Yep, so I'm not sure how to work the board.
Just the down arrow on the left-hand side. There you go.
Is there a remote or anything? Where's Renee?
Yeah, so our presentation includes background on the subject property. Now I'm questioning whether or not that's.
That's, no, site and history not relevant.
So, Chair Hennessy, we did describe the history of the property and the historic uses as part of the planning board hearing process. So this is not new information, and it informs how the design was derived, which was also presented to the planning board. Again, we'll be guided by you, but I just want to be clear from the record that there's fundamentally no new information here. This has all been discussed, the historic uses and how the design was derived.
Mr. Parsons?
Attorney Brodsky, my understanding is that you're here tonight and before us to appeal the denial of the planning board's decision for lack of information and so forth. It's not our decision to go back through all your presentations and everything else. We're here to decide if what the planning board did was correct or not.
Mr. Parsons, I will defer to the judgment of the board, but this is some of the information that provides the context for the design for which we were, I guess, alleged not to provide sufficient information for the planning board to review the design guidelines. And so this is how the design was derived. We're going to describe for you how the design changed in direct response to comments from the planning board, from the public, from department, as well as staff of the town. This is, again, our burden to show why the project complies with the design standards, because the design has to comply and comport to what the town was looking for.
Got it, and I'll just, and again, I'm not trying to be a barnacle in the boat of progress here, Attorney Brodsky, but within your appeal memo, that information is not discussed. So I'm going to respectfully ask the representative here, Mr. Fleck, to sort of move beyond that to, I would even, it'd be fair to say, you know, the planning and diligence. So it's a few slides in and begins with 2024. I think, you know, most folks in this room drive by this property on the regular, and we know what's there, we know what's been there, and we know what the property owner intends to put there. So I think we can save time by just going into the planning and what was submitted on your behalf, on the property owner's behalf to the planning board.
Chair Hennessy, I have a suggestion, which is in response to your concern. Perhaps we should have Mr. Schulte get right into the heart of the site plan and the design guidelines.
That, I would agree to that.
And all of this information is contained in the administrative record. Our intention was to summarize that in order for us to meet our burden of proof. You have every opportunity to review all of those documents, and we encourage you that you do that. We're just trying to be helpful. So why don't we pivot? Again, we have every interest in trying to at least close the presentation portion of the hearing this evening.
Okay. Yeah, that's fine. Again, this stuff is unnecessary for our purposes tonight, as in this slide and maybe the next one or two. So I'm fine with that pivot.
Members of the board, Carlos Schulte with Civil Environmental Consultants. We're the civil engineers on the project. I'm a licensed professional engineer in Massachusetts, and I'm a principal within our civil engineering practice overseeing our team of designers and engineers. This slide that we have in front of you is a direct excerpt from our site plans that we had that were part of the site plan review application in front of the planning board. I'll spend less than a minute just highlighting what this project is, and then I'll talk about some of the compliance with the design review guidelines. So the property, for everybody's benefit, is 4 parcels of land, 3.3 acres in total. And then there's the 9 units proposed with accessory community space located at the southerly end of the site. We have additional landscape open space, which is provided at the southerly end of the site and the northerly end of the site, as well as new pedestrian walkways along the waterfront that we have, as well as parking for the residents and parking for the proposed associated ancillary marina use that's proposed with the dock and the boat slips on the property. So very high level, that's the project that we're talking about here. This is the final site plan that was presented to the planning board that was part of the basis for the vote. I'll talk about a little bit about the review process and the number of comments and responses that were provided to the various town departments to provide a flavor for the volume of information that was exchanged back and forth between the review by the various town departments and a third-party peer review consultant that was hired for the project, and the responses that were provided addressing those comments along the way. Ultimately, we believe in satisfaction to everybody, all various departments from the town, as well as the peer review consultant. So just highlighting them very quickly, the whole sewer department, they provided 10 initial comments at the very beginning of the project, which we addressed, made some revisions. They provided 5 follow-up comments, which we then subsequently addressed with no further comments from the whole sewer department. The Department of Public Works had similar comments over the review process, where there were comments about drainage and connectivity and improvements within the right-of-way. Those were also addressed in a written response and peer review memorandum that was provided as part of the record. The Weir River Water Authority, that's the water supplier for the town of Hull. We received comments from them as well that we incorporated into the project design and revised the plans and responded to those comments as well with no further comments from the Weir River Water Authority. The Hull Police Department, we received comments from the police department as well. Responded to those in writing with the response to comments memorandum, incorporated revisions that included stop signs, modification, removal of parking spaces that were in the public right-of-way, and revisions to the plan design. The fire department as well, we received comments from them, incorporated revisions, and then from Tessia Engineering, which was the town's third-party peer review engineer.
Let me just bump in real fast, is like so in the first 3, so Hull Sewer, Hull DPW, Weir River Water, or actually the first 2, Hull Sewer and Hull DPW, sign off, as it relates to the sewer department, sign off filed May 11, as it relates to Hull DPW, comment filed May 11 on final plans. The other ones in this roster do not have, and this is me just being, more granular, do not have a similar time frame. So obviously, the hearing that served as the basis of the decision was on May the 19th. Oh, pardon? May 14th, I'm sorry. May 14th, and what I'm trying to figure out is if you have, to the extent you have it in your brain, like as it relates to Weir River, Hull Police Department, Hull Fire Department, and the peer reviewer, well, actually not necessarily the peer reviewer, but the Weir River, Hull Police, and Hull Fire, you note that these things were addressed or what have you. Can you explain with more detail, to the extent that you know it, like how they were addressed and how these issues were presented or forwarded to the planning board?
If I went through the comments one by one, I think we'd be here for a while. It's part of the record. So we prepared in response to these various comments. We had a response memorandum, which is part of the record that you have, that was provided, that addressed each and every comment received by these various agencies along the way.
Okay.
So that is part of the record. Yep.
Part of the record that was presented.
It is, yes. Correct.
To the planning board.
To the planning board, yes. All of our responses were addressed through the planning board to the various departments that made their comments.
And we have all this information ourselves.
You do.
Zoning board.
Yep.
Tennessee, we do have copies of those as specific exhibits to the appeal.
Yep.
Separate and distinct.
Right, I mean, to the extent that if it may be helpful to identify, not like book page, but like if we want to, you know, for the benefit of those watching and those in this room who may not be so intimately familiar with the appeal memo and the various exhibits, again, asking you to do a lot from the dais up there, but if there's, you know, reference to specific exhibits that you could identify, that would be helpful, just to keep things sort of chronological.
Sure. I would have to refer to Attorney Brodsky for how the exhibits are labeled, if the board needs that information.
It's however it would be helpful. Just the whole kit and caboodle.
Why don't you proceed and see if I can
Okay.
shed some light? I do know that the
I have no problem with,
transportation memo is exhibit number 11, and we did not, obviously, we did not include all of the documents within the underlying record as exhibits. We just included the relevant ones that were the subject of really the decision.
okay, and I have no problem with there being a tag team approach to the presentation. So I think for purposes of what's going on right now, any sort of reference point to a particular exhibit that supports what the speaker is talking about would be helpful to keep us organized.
I will note that I believe the last response to comments memo that we provided was dated April 30th, 2026, and was built chronologically, essentially as part of the record addressing the cumulative comments along the way. So that's probably the most relevant last document that accompanied the revised plans that were part of the record. So then the relevant topic, without getting into the details about the actual design of the project and the nuance of how it changed over the duration of the many months of permitting with the planning board, was how it complies with the requirements for the design guidelines. So as mentioned earlier, there's the two relevant sections from the zoning bylaw that talk about the design guidelines and how this project should be viewed and reviewed in the context of the scope of the planning board's review. And I'll just go through these one by one, just identifying how we address them along the way with the various revisions. Please, if there's any questions, feel free to jump in at any time.
And not, sorry to sound like not to make your job harder, but I think it's more instructive is that, so where on this slide deck you have, you know, A through L, that corresponds with, I think for the most part, 410, 4.1D that has 1 through, 1A through 1H. And then there's also section 2 that goes, well, actually, this would be more helpful for clarification purposes. So 410-4.1 has a subsection 1 and also has a subsection 2. Subsection 2 is A through L. Subsection 1 is A through H. So I take it that this must correspond with subsection 2. Would that be accurate to the extent you know?
Yes.
Okay.
So the metrics that we look at are these design compliance requirements, right? So the first one we look at is how does the site maintain, protect existing site features that should be protected? So as part of this project, there's an existing dock on the facility, which we will be maintaining and protecting that dock as part of the facility. There's existing access to the waterfront in this particular location that will not only be maintained but improved with the project. So
And as it relates to that piece, is this, again, not necessarily relevant tonight, but when you speak to the dock, is this the dock that has been more recently sort of fenced off because of whatever insurance issue? Or I just want to get placement in my mind as to what you're referring to.
Sure, there's two properties, or two disconnected parcels. We have the main development parcel, and then this parcel is also part of the assessor's parcels, part of the site. I think the dock in a state of disrepair that was discussed, that should be removed, abandoned, which I believe the team is agreeable to, is the dock on the disconnected piece. There's also a existing dock that's in a state of disrepair that's on the development parcel that we would be improving and repairing.
Got it. And the one that's been fenced off, is it on the developmental parcel or the straggler just above?
Yeah, I don't believe this area's been fully fenced off,
Yeah.
but this whole parcel is the parcel that everybody drives by that has the degraded buildings, that is fully fenced in.
Okay. All right, continue.
So as it relates to some of the existing site features as well, the seawall and the waterfront improvements, we're not proposing to do anything seaward of the bank. So we're proposing to do all of our landward of those coastal resource areas. So we are maintaining a lot of the existing site features that exist today. As part of the protecting of adjoining premises and maintaining provisions for surface water, drainage, sight, sound, wind barriers, preservation of light, air, and quality and views. This project was designed so that it would provide views through the site. It would fit within the context of the neighborhood. We are within the zoning requirements. So as mentioned earlier, it's fully zoning compliant. The buildings were broken up so that there would be view corridors between the buildings as well as below the buildings instead of one large wall of massing that we felt would be more of an impediment to views and to the community. So the site was designed specifically to fit within the context of the neighborhood and the coastal environment. Vehicular and pedestrian movement and accents, making sure that it was safe and convenient. We provided a traffic memorandum that was part of the exhibits. If you need the exhibit number, Attorney Brodsky can provide that. But within that traffic memorandum, we looked at the sight lines. We looked at driveway locations for access into and from the development, as well as parking spaces along the frontage over the course.
And yeah, and again, my apologies for interrupting, but what you're presenting now, sir, this is information that your testimony tonight is information provided to the planning board that supports your position that the project is in compliance, and as a result, the planning board decision is incorrect. So none of this stuff is new or hasn't been either, analyzed and evaluated by the planning board. Is that correct?
That is absolutely correct. This is just background on how we addressed the concerns for the design review over the course of the permitting process.
Chair Hennessy, just as a point of information, the original traffic memorandum is Exhibit 11 to the appeal complaint. It was later revised to address a further comment by Mr. Chesia. That's Exhibit 12.
Yep. Thank you.
Thank you. So the project was revised and redesigned. There used to be 2 driveway entrances with parking underneath the units. Based on some of the comments and the feedback from the various departments and the peer reviewer, we revised the design to consolidate it with 1 driveway entrance and moving all the parking to one end of the site. So certainly all the commentary and questions and concerns that were raised during the review were incorporated into the project design, and we were responsive to those comments. The next comment, D, parking and loading, a similar type of comment. We looked at the parking and how access to and parking for the development would be incorporated. Initially, we had substantially more parking proposed at the development. There was commentary over the course of the planning board review process where there was concern that there was too much parking. So we reduced the amount of parking, again, consolidated it to one portion of the site. It's zoning compliant. Again, we're providing the parking that meets the zoning requirements for density, for the number of spaces, as well as the dimensions and the layout, as well as providing loading space for accessibility well. Again, fully zoning compliant, part of the record in response to comments over the review process. The next comment, as it relates to refuse disposal, there were questions on how that would be managed. We incorporated into the plans locations where there would be private trash located for each respective unit. So addressing that comment on how the trash would be maintained and located within the development. Building and landscaping relationship. As part of each package and each revision that was provided, there was a set of landscape architecture plans that were prepared by a registered landscape architect that addressed the landscaping for the development, addressed how it would work picking coastal zone management compliant plants. Also part of the peer review looking at that. So everything was picked and analyzed and incorporated into the project design as it related to the context of the community and the landscaping. The next one, pollution, corrosion control, stormwater runoff. That was a focus of the third-party peer review. And that was a big part of this project design in the location where it is. We want to make sure that the stormwater management design was performed and reviewed appropriately. We responded comment by comment to the numerous comments that the peer review engineer had to the point where at the end of the review process, the remaining commentary that was in that letter was basically items that could be conditioned should the planning board want to condition them as part of the approval. There were no more critical design comments or required revisions in that last peer review memorandum provided by the peer review engineer. So everything is fully compliant with the stormwater management standards and all the requirements as it relates to stormwater management and erosion and sediment control, pollution and runoff during construction as well as following construction. The flood damage prevention. The site is located in a FEMA regulatory floodplain. It's in an AO, an AE, and a velocity zone floodplain. All of the proposed structures were located landward of the velocity zone, so everything is outside of the velocity zone. Everything is proposed in the AO flood zone and designed to be compliant with the ASCE flood requirements as well as the building code requirements. All of the buildings are located on piles and elevated not just with the freeboard required above the regulatory floodplain, but with additional elevation to provide sea level rise resiliency in the future as well. So everything exceeded the requirements as it related to design and construction within the flood zone and the associated regulations with those. The environmental impacts. Again, that was part of the stormwater management review and the analysis as part of the project. It fully zoning compliant as it relates to open space, as it relates to access, as it relates to the overall environmental design of the project, stormwater management, and the regulations for the Wetland Protection Act, as well as the stormwater management standards. Again, everything very explicitly identified on how compliance was achieved, also reviewed by the third-party peer review engineer with no further comments. The outdoor lighting, as part of the overall project plan set with each iteration and revision, a updated lighting plan with photometrics analysis was provided with each set that was provided for a revision. So there was a light analysis with specific lights proposed and chosen, showing what the various light levels would be at the ground level. Again, compliant with the town's requirements for what those light levels were, providing the information that would be suitable for review as part of that process. Providing vistas and the view corridors. It's a similar comment. It gets kind of repetitive between section 1 and section 2 in that zoning in the zoning section, but touched on it earlier, making sure that we preserve the open space at the northerly and the southerly end of the site. breaking up the buildings, so we ensured that there would be view corridors between the various buildings, well beneath them, based on the elevations that they were elevated above the floodplain. It provided views not only in between the units, but below the units as well. So providing those open space views and vistas throughout the development. And then the last one, again, a little bit repetitive, but as it related to flood damage prevention and floodplain compliance, it exceeded the regulatory compliance for the floodplain requirements, the building code standards, as well as the construction of the buildings on piles, which further demonstrated the compliance with the Wetland Protection Act and the building code standards for these types of developments in a regulatory floodplain. So with that, so that was the compliance as it relates to how we met the various metrics for the design guidelines. I'll turn it over back to Attorney Brodsky to talk a little bit about the overall process and the timeline of the various materials.
Thank you, Carlos. So, members of the board, again, one of the grounds for denial of site plan approval by the planning board was the allegation that the planning board was not afforded sufficient time to review the project. So I'm just going to briefly go through the relevant chronology and point out a few key facts. First, the LLC submitted to the planning board its site plan review application on January 21, 2026. And you need to understand that the site plan review bylaw requires that the planning board shall conduct a public hearing within 65 days of filing of the application, shall render a decision within 105 days of filing of the decision, and may seek comments from any town boards or department, but those comments must be provided within 35 days of the board or department receiving a copy of the application. The bylaws uses the word shall. It's mandatory and non-discretionary. You should understand that the planning board did not open the public hearing until the end of that 65-day period. In fact, on day 56 after we filed our application. And in fact, the planning board did not render its decision with 105 days of filing of the application. And in fact, the LLC granted 2 additional extensions of time in which it had no legal obligation to do so.
Sure, but to dispense with that, the hearing was held within the time frame required by
Yes, sir.
the bylaws, and that the parties agreed, which is often the case in certain circumstances, for an extension of the statutory timelines in order to get everything together, correct? So
And I'm going to explain again why additional time was required through no fault of the applicant. Again, here, I'm demonstrating the applicant, the LLC, working with the planning board to afford it sufficient time in which to review the project. Again, as noted, the project was peer-reviewed by Chesia Consulting, and as Mr. Schulte indicated, all of Mr. Chesia's comments were addressed. And I'll note, because this again is an allegation and a ground for denial, all of those invoices paid. You should note that, again, we filed the application on January 21, but did not receive a copy of Chesia's proposal for peer review until March 2nd. And we did not receive the first report from Chesia Consulting until after the first public hearing on March 18th. And just to be clear, there were multiple public hearings. Public hearings on March 18th, 2026, April 8, 2026, April 22, 2026. And the parties, the LLC as well as the planning board, targeted a final hearing date for May 14th in order to review a draft decision that was to be drafted by the planning board and shared with the LLC for comment prior to that May 14, 2026 public hearing.
And just so that I'm
This
getting
calendar, yes?
Sorry, Attorney Brodsky, just so that I'm getting myself not overly confused. I referenced the prior speaker confirming that certain additional information, comments, or what have you, were submitted to the planning board on May 11 of 2026, which would have been, just a few days prior to this May 14th hearing. I just want to make that clear. Is that seems
Are you
to
talking
be-
about our responses or Mr. Chesia's responses?
No, I'm just simply referring to one of your slides that talks about the review, and it's a question that I spoke with the engineer, where it says comments filed May 11 as it relates to Hull DPU, Hull Sewer Department, signed off, filed on May 11. So both of those dates are sort of, there's a flag in the sand as it relates to when this information was sent off to the planning board a few days before this May 14th hearing. I just want to make sure.
So the applications were provided to the various departments in January. We, together with the planning department, chased all of the various departments for comments. We received mostly emails over the course of this, and I think the final sign-offs, after chasing them in anticipation of the May 14th hearing, were received. There's no additional information. We just wanted to make sure that the record was going to be complete so that the planning board could act on May 14th. And, I'm sorry?
Can I ask a clarifying question? Which of those, on that slide, of those public bodies are within the list that if they don't respond within X days, does the ordinance not say that they're deemed to have approved? So it was maybe extra that you were both responding to the comments and providing that data to the planning board, or am I reading the ordinance incorrectly?
Any comments within the 35-day period, but we addressed all of the comments, treated them as all valid comments.
Nonetheless.
That's correct. Again, in our effort to address all of the questions of the planning board, departments, staff, as well as members of the public. And as I said, there was a discussion during the public hearings as to this process. And this is a typical process in front of the planning board. I've done any number of projects before the planning board. We target a final hearing date. Planning department prepares a draft decision. That draft decision is shared with the applicant prior to that definitive public hearing date, so that we can provide comments. And at that last final hearing, the board would presumably close the public hearing and vote to issue a decision. But we're all working and rowing in the same direction to get to a decision with reasonable conditions that are agreeable to all parties. And we had no reason to believe that that wasn't the case here.
And just to bat sort of out of order, Attorney Brodsky, that draft decision, of which is included as an exhibit, do you have in your memory bank the timeframe when that was received by the LLC?
It was received several days prior to May 14th. The date should be in my appeal memo. I didn't bring a copy with me. We turned around comments as quickly as we could, and certainly prior to that May 14th date. And as I said, everything was going along smoothly. We had positive comments from the planning board members who attended the April 8th meeting. We were all moving in the right direction. And then on April 27th, as indicated in our appeal, things went sideways. We had a planning board member present a motion for the planning board to engage independent legal counsel to challenge Commissioner Kelly's zoning determination.
That has nothing to do with this decision, Attorney Brodsky. So rather than even if it's not explicitly your intention, I don't want to inflame anything as it relates to that. So that kind of things that are outside of this decision itself should remain within your brain and nothing else.
It's actually mentioned in the decision. There was an acknowledgement that that was done, but that was not going to be a ground for the decision. But the planning board still objected to that.
I'm going to tell you, if it's not a ground for the decision, then it has no bearing on tonight.
Yes, sir. As I indicated, the public hearing was continued to May 14th, which was intended to be our final hearing date. We were provided with the draft decision and provided comments back to the planning department as requested and as previously agreed. And prior to the May 14th hearing, the planning department requested that we continue the public hearing and provide a further extension of that hearing date. And this is relevant because this is a procedural error that also requires this matter to be remanded. And I've explained the reasons for that, concerns with the upcoming planning board election. And the LLC agreed to request a continuance. And it also made sense because we wanted additional time to work through the comments to the draft decision that was provided by the planning department days prior to that May
Okay,
14th date.
so parsing what you just said, again, the first part of your statement as it relates to any upcoming elections has no bearing on tonight. But I think the more important issue is, okay, planning board reaches out, apparently in a gesture of good faith, to try to figure out a time where they can substantively review any recent submissions by the LLC leading up
Sir,
to that May 14th.
That was not the reason for the request for continuance, which is why the reason is relevant.
Okay, I say that it is not, and ask that you continue.
Thank you. And so, in response, the LLC requested a continuance to May 27 and agreed to extend the decision-making period again for a second time through June 4. That request is reflected in my letter to the planning board. And in that letter, we indicated that we were not intending on attending the May 14th hearing, as is the usual practice before the Hull boards. As you know, you will often have applicants request continuances, and I've never been required to actually attend a public hearing to appear to request that continuance. As a matter of courtesy to applicants, the boards grant continuances, and I've never been denied that request. So we made it clear that we weren't going to be there, and we asked that there be no substantive discussion without us being
And
present.
just to ground what you're saying right now with a submission as part of your appeal memo, I'm referring to what I believe to be Exhibit 16, which is a May 14, 2026 letter from you and your law firm to the chair of the planning board as it relates to this continuation issue.
That's correct.
So I note that nothing in this letter speaks to some of the sort of anecdotal stuff about elections or anything of that nature. But I just want to make it, I want to be clear for myself and the board members here that this letter was sent to the planning board at some point on May 14, 2026, prior to the hearing that evening on May 14, 2026.
When the request was made to us to please continue the hearing. That's correct.
Okay. And I read in this letter, it says, we had further conversations with Chris Delorio, the Director of Community and Development, who requested that the LLC agree to 2 additional meetings and an additional extension of the decision period. You state it is unclear that 2 additional meetings are necessary, and the LLC repeats its request to please continue the public hearing scheduled for May 14, 2026 to May 27, 2026, and that this would be sufficient time for the LLC to review the proposed conditions, which the LLC has just received. So that would be, was that the draft decision that you're referring to in this letter?
Yes.
Okay.
And again, I just to put this into context, we filed the application in January. We're now in May, some 4 months later. We've had 3 public hearings, meetings with the Design Review Board, departmental meetings. It's a lot of time to be spent reviewing a 9-unit multifamily building. But we were committed to this process.
Got it. And you know, to put that into further context, it was a collective decision between the planning board and the LLC that the best use of time would be to allow for this, you know, again, within the timeframes that are required by the bylaws, but that additional time in order to get all of the information that the engineer just, you know, told us about to the planning board so that they can review and ultimately issue their decision, be it that proposed or something different, which is why we're here for tonight.
Again, within reason, we were very concerned with the passage of time and how long this was taking. And that's expressed in the schedule. So again, we are cooperating but expressing our concern with the passage of time. It's very expensive to assemble teams of consultants and lawyers to have repeat hearings. We needed to bring this matter to an end.
Okay.
As indicated in our materials on the May 14th hearing, which we did not attend, the planning board refused to consider our request for a continuance, substantively reviewed the matter without us being present, including taking public comments, and voted to deny site plan approval without making any findings during the course of that public hearing to support their decision. And in fact, after the vote, the record reflects that they indicated that they would have town council draft the findings after they made none during that public hearing.
And is
then-
it your contention, Attorney Brodsky, that the planning board's decision on May 14, 2026 to deny the continuance and proceed based on the information presented, is it your position that that by itself is a violation of the applicable bylaws?
Yes, because I believe the case law supports us that they need to make findings in support of their decision, but the problem is compounded because on May 19th, the planning board filed a decision, the written decision that's the subject of this appeal, with the town clerk without conducting any public meeting to review any findings, to review the decision, and approve the decision, as this board regularly does. You review decisions at a public meeting, not necessarily a public hearing. You review the findings to make sure that the findings are in fact accurate, and then you approve the decision before you sign it and file it with the town clerk, and none of that was done here. Again, a procedural error that in and of itself warrants the remand of this matter back to the planning board.
And not to sort of split hairs, but we all recognize and accept that there was indeed a public hearing on May 14, 2026, where planning board was present, members of the public were present, but that the LLC was not present, correct?
Correct.
Got it.
Because we conform to the usual practice before the town boards of not appearing because these continuances are routinely granted. I cannot recall an instance in the town of Hull where any request for continuance on any of the matters that I have been responsible for were ever denied.
Got it. And is it also your position that the planning board's determination that they would proceed and ultimately render the decision that is the reason why we're here tonight was also in violation of the applicable bylaws?
Yes.
Okay. And where in the bylaws does it say that they can't do that, if you know?
I can provide a citation. I would refer you to the case law, which I believe is cited within our appeal, of the requirement of boards to issue findings in support of the decision. I'm fairly certain that's contained therein, but if not, I can provide that information to you.
Attorney Brodsky,
Yes, sir.
is it a guarantee that they have to give you that continuance?
No, sir. You're absolutely right. It's within their discretion.
Thank you.
Can you
I-
clarify
But
whether?
I do believe that they should at least vote on the request for a continuance, not ignore it and proceed without an applicant.
So just to clarify, there was no affirmative vote or denial, or no affirmative vote on the question of continuance?
Correct. There was a discussion. They never took a vote on the request for a continuance.
Okay.
Attorney Brodsky, and I was there that night at that meeting.
Yes, sir.
As a citizen, and if my recollection is, they did take a vote to continue it. I mean, not to continue it, they did take a vote to.
No, sir, I believe you're mistaken. I did, I watched that hearing. I obviously wasn't present, and we did review the video recording. I can be corrected on this. I'm fairly certain that that's the case, that there was no vote on the motion or the request for continuance. the board went right ahead and voted to deny site plan review.
Okay.
I can firmly, my recollection is that a motion was voted on that night.
And
all
just
review the
rather than the
videotape.
back and forth, because I think we could do this forever, the planning board is ultimately going to have their opportunity to answer our questions and respond to what you are making here. So I think we'll be able to put that issue to bed at some point.
Thank you. So, as I mentioned, there are procedural grounds alone for a reversal of this decision and a remand to the planning board. Substantively, and again, this is addressed in my appeal, the decision fails to allege with specificity what additional information the LLC allegedly failed to provide to the planning board, with one odd exception, which is a reference to a model. Now, the design review guidelines do give the planning board the power to request a model. And we were asked to present a physical model, as you'd see in a 1950s movie, that you build a model. As we have explained to the planning board, and in fact, we've had this conversation with respect to other projects, no one builds physical models any further. And so we provided computer-generated 3D renderings, some of which were included in the PowerPoint and skipped over, but are also contained in the administrative record.
Okay.
The suggestion that a project of this sort should be denied site plan approval for failure to provide a physical model, I suggest is unreasonable in 2026.
All right, and with that being said, I recognize your position on this and what may or may not occur in the trades, in the year 2026. But I do note that the bylaws that stand as they are drafted, that under 410-4.1 C3 F, which is what the planning board's decision references, it states a model at the same scale as the site plan showing the entire project in its relation to existing areas, buildings, structures, and roads for a distance of 100 feet from the project boundaries, and prefaced in subsection 3 ahead of these various things. It says additional materials required. After initially reviewing the proposed site plan, the planning board may require that the applicant submit any of the following materials. So Attorney Brodsky, is it fair to say that you would agree that 410-4.1 C3 and then A through G are all pieces of information, documents, or other supporting information, that's what the planning board would require, and that just because industry standard is slightly more advanced in the sense that, okay, there could be 3D renderings on a piece of paper, but that as it stands, that's what the bylaw states, correct?
So, if I
It's
might.
just a yes or no. Like, does the bylaw states that it?
Fortunately, sir, I don't need to answer your questions yes or no, since we're not in a court and I'm not under oath, and this is not a cross-examination. I've acknowledged that the.
I'm just, everybody just relax. I'm just
I've
acknowledging,
acknowledged that the
I'm
bylaw-
asking you, Attorney
Sir.
Brodsky, that 3F states a model at the same scale as the site plan, showing the entire project in its relation to existing areas, buildings, structures, and roads for a distance of 100 feet from the project boundaries. That's what the bylaw states.
That is correct. The
Okay.
bylaw has not been changed in some time. That information was discussed in connection with the Paragon project, which I had the pleasure.
That is irrelevant
It-
to this
it is, sir,
process tonight.
because
It
the-
absolutely is not, Attorney Brodsky. We're here on this project and this project alone, okay? And as it relates to any planning board requests for information, they may require this. It doesn't speak to anything. So I understand your point and your connection to the
We have no way of
Paragon.
satisfying that request in 2026. We know of no one who makes physical models. Everyone uses computer-generated three-dimensional models that are to scale, and that's
And
the
with that,
industry standard.
so those the alternative version of what the bylaw indicates may be required by the planning board, these 3D drawings or what have you, would that fall within 3A that says conceptual drawings of buildings and structures to be erected, including elevations?
Elevations are, I guess they're one-dimensional. They show the
Right.
side views. These are multi-dimensional renderings that give you a depiction of what this looks like in the context of the site. That's the whole purpose of this bylaw. That's the purpose of design review, is to take a look at these buildings within the context of the site and make sure that they're consistent with the neighborhood architecture, the massing is correct, and it fits within the neighborhood context. And all of that information was provided. And I suggest denying site plan review because of our inability to produce a 1950s-style cardboard model to scale is not a reasonable resolution of that issue.
But nonetheless, that's what the bylaw states.
The bylaw also says that the planning board was to render a decision within 105 days, and it didn't do that.
At
We're gonna
your own,
strictly
you guys accepted that, though. Like, it was, there, like this, the issue of time, I understand completely. But as far as I can tell, there is an agreement amongst both sides to extend the time frame so that by that very agreement, neither party can disparage the other about not sticking to the 105-day deadline. I don't see it as being the case. Yes?
Does it say physical model? Is the word physical model written in the bylaw?
It says a model at the same scale as a site
3D
plan.
rendering is a model. It does not say physical model, it says a model. A 3D rendering is the industry standard of how you model buildings.
Okay. You, Ed?
Yep. Attorney Brodsky, the renderings that are in the brochure that you gave us, are those the renderings that the pictures exactly what was going to go there?
Those are conceptual renderings that are computer-generated in reliance upon the project plans.
But it was going to be this design, or was it going to be?
I'll have to defer.
Yes, that's a 3D model.
Okay.
3D model of what was going to.
So when the project was done, this is what it would look like?
Yes. With as much accuracy as a physical model would be representative of the project as well.
Thank you.
Again, one of the allegations and basis for the denial was the assertion that the LLC failed to provide adequate time to review the application. I think I've beat that. I shouldn't say that. That's not appropriate to use. We've addressed that issue at some length. The next ground for denial is an allegation that we failed to provide sightline traffic information to the planning board prior to May 14th, and that's erroneous. You have the two traffic memos, which are Exhibits 11 and 12, that specifically provided that sightline information. And I'd ask the board to take notice of the town's traffic study that was performed in the same vicinity in connection with the seawall project, which was performed by Green International and is publicly available on the town website. That was made available on June 26, which also studied the area and corroborated our traffic consultant's opinions with respect to that. So the traffic issue is.
Sure.
I apologize for the interruption. I don't believe that's part of the record. That came after the planning board.
Yeah, so, and,
That noted.
yeah, I mean, that, so what we're focused, our sort of date of destiny here is May 14 and May 19. Anything after the fact has no bearing on today's process. One thing I wanted to ask Attorney Brodsky is that Exhibit 13 to your appeal memo is a May 12, 2026 letter to the planning board sent via email and first-class mail. That would have been 2 days before the hearing and 2 days before your other exhibit, which is 16, to discuss the continuation. And I don't want you to have to rush looking for stuff. So when you find Exhibit 13, just let me know.
Those are all the reasons that the board gave on the 14th. Deny this.
Chair, I understand you're referring to exhibit number 16, which is my May 14th letter?
Well, two parts. No, so yeah, so what I'm just trying to provide is sort of a timeline for the board tonight to figure out the flow of information to the planning board. And what I was referring you to was what I believe to be Exhibit 13 in your appeal memo, which is a May 12, 2026 letter to the planning board. And I anecdotally say that that was 2 days prior to the hearing and 2 days prior to your Exhibit 16 correspondence to the planning board that talks about the continuation and whether or not there's a need for additional meetings. So the focus of
I
my,
have exhibit 13th, which is an April 16th, 2026 transmittal letter, transmitting revised architectural plans and facility space renderings.
let me see if I can, my apologies then. I just want to make sure that we're all on the same page here. In terms of, and if I erroneously put down the wrong number, that's on me. Where was Exhibit 13? Yep, okay. So what okay, all right, so I must have gotten this thing, I got it incorrect. So this is actually, what I'm referring to now, Attorney Brodsky, is what would be your exhibit number 12. This appears to be a letter, again, dated May 12, 2026, to the planning board from your office regarding a transportation memorandum prepared by CEC Inc., dated May 12, 2026. We're on the same page, right?
That's correct. We had just received Mr. Chessia's final comments, one of which concerned additional information regarding traffic, and I'd have to have Mr. Schulte address that. We quickly turned around a supplement, and we're prepared to present that on the public hearing on the 14th. And obviously, we didn't have an opportunity to do that. But we were endeavoring to, again, check off all of the boxes and address all of Mr. Chessia's comments. So that was a specific request by Mr. Chessia for additional traffic information. And again, Mrs. Schulte can speak to the technicalities of that.
And the receipt of the peer review report from Mr. Chessia,
I think that date would be reflected in my appeal memo. I did not bring that up with me. Literally, I think days prior.
okay.
The original transportation memorandum, which is, I would assume is the largest amount of the
Yes.
traffic information, was submitted on April 1st.
Correct. At the
Okay.
beginning of the process, when we were asked to provide traffic information, we provided that. It was subsequently peer reviewed by Mr. Chessia. We received his comments. We quickly turned around the additional information that he requested to demonstrate that there would be no traffic effects associated with this project. Again, it's only 9 units. It's a very small number of vehicles in and out. We provided that data as well as a line of sight analysis. But
Go ahead,
the purpose of the May 12th submittal was to address that additional comment by Mr. Chessia.
All right, so at least on May 12th, at least on May 12 of 2026, that May 14 hearing was scheduled to go forward.
Correct.
And the LLC submits this transportation memorandum a couple days before to address subsequent issues by the peer review
It
report.
had just been provided to us. That is correct. Yes, Mr.
Attorney
Parsons.
Brodsky, was there a traffic study done?
Yeah, there's a traffic memorandum. What do you mean by a traffic study? These have special connotations in the traffic engineering world.
But was there a
We
physical?
provided, I believe, and Carlos should probably speak to this, the information that was provided.
Would you like me to go up to the podium
You
or
can
from
go
right
from
here?
there.
Yeah, so based on the size of the project and the fact that there was prior development, there preceding what we were proposing, it would have effectively been a reduction in trips from the development based on the number of housing units and the commercial building that was there that was no longer going to be there. So it was deemed not necessary to provide a full traffic impact analysis that looked at trips and level of service and intersection queues and things like that, because it was such a small project and was actually going to be a reduction in trips to the development. So the scope of the analysis, as was discussed with the planning board, was focused on safety and intersection site distances, on how that worked at the proposed driveways, as well as coming around the corner. And then at Nantasket Avenue, where it turns into Fitzpatrick Way. So that was the piece of information that was identified in the May 12th memorandum from Chesia Consulting. We provided that additional intersection analysis, which was that Fitzpatrick Way, Nantasket Avenue, and then where Nantasket goes up the hill there. That intersection was the additional information that was included in the memorandum that we provided on May 12th, the same day that we got the peer review comments, because we were trying to be responsive and trying to get the planning board the information they were asking for and the peer review consultant was asking for.
Okay.
So we provided all that information.
Now, did the planning board request a physical traffic study?
It was not requested from us, no.
And then in this, Attorney Brodsky, or you're Mr. Schulte, right?
Correct.
Okay, so in this, what we want to call a transportation memorandum, there is, your recommendations at the end of this document. There's 2 paragraphs there. The first speaks to CEC's position that the proposed driveway locations are acceptable. And then there's a second paragraph that states it's recommended that the site triangles at the proposed site driveways be maintained free of site obstructions such as buildings, walls, hedges, bushes, low-growing trees, etc., to maintain a clear line of sight to potential conflicting vehicles. Now, those recommendations, like how is that interpreted or digested by the LLC, and was that it's a 2-part question. Like, how is that sort of interpreted by the LLC, and is these recommendations, are they things that would have gone to the planning board as it relates to those specific topics that you recommend?
Sure, yeah, so in response to that, so as part of the analysis, that's a common recommendation, right? You wanna make sure that you don't have any signs, you don't have any buildings that are gonna block those views, and you keep your landscaping below a certain height so that it doesn't get in the way of the sight lines. Part of the analysis in that memorandum was to show what those sight lines would look like so that we could demonstrate that for this particular project, we do not have those conditions. So that was part of the analysis in this memorandum, was demonstrating that the project keeps those areas free and clear. It's not uncommon to have those also, be a condition for future maintenance and landscaping for the future development, so that that does not become a problem in the future as well.
Okay. Back to you, Attorney Brodsky.
Thank you. The next ground for denial was the assertion by the planning board that there were outstanding concerns regarding ownership of one of the parcels of land. So this property consists of several parcels of land. I don't know how far deep you want to get into this. A question was raised regarding title to one of those parcels. Not an issue for the planning board. As we explained to the planning board, far beyond its jurisdiction under site plan review, may be a concern between the seller of the property and the buyer. This property is under agreement with us. We've yet to take title. We explained that that title issue had been raised with the seller, who agreed to cure it. In fact, it has been cured. Again, you don't want to hear any more information beyond the record. The point being is that an issue with respect to title is not grounds for denial of site plan review. We demonstrated that we had site control by virtue of our purchase and sale agreement, and we said to the planning board that in the event that we were unable to obtain clean title to one of the parcels, we'd obviously have to come back and modify the project. But that was not a legitimate ground for denial of site plan review.
One of the, what you're referring to is this site plan decision of May 19, 2026 that has particular findings, one of which speaks to this issue
Unknown parcel.
of ownership,
Yes, sir.
right? And has that, like, as we sit here today, has the LLC taken title to these parcels?
The closing has not occurred. I don't know. I'm not running the real estate deal when the closing is scheduled to occur. But I can tell you that the seller cured that title defect, which is fairly typical in connection with the purchase and sale of larger parcels of land. That the title attorneys review title. They raise questions regarding the quality of that title, and oftentimes the seller will be obligated to cure it.
Sure.
But regardless, that is not
It's not an
proper
appropriate
element
issue to be
within a
addressed
finding
by the
of the
planning board
site
and
plan
site
review.
plan review.
Is that your contention?
That is correct.
Right, and what I was trying to figure out here is that the findings, so there's a difference between findings and there's a difference between the decision section. So the findings have the specific issues as it relates to the bylaws that the planning board elected to deny. It also includes some of this anecdotal information as it relates to title. But that the decision itself, where the sort of rubber meets the road, does not focus on the title piece. So is it your position, Attorney Brodsky, that the planning board is prohibited, even in their findings, to mention issues of concern that may not be dispositive one way or the other on its ultimate decision?
So I respectfully disagree with your summary. The decision is a denial. There needs to be grounds, legitimate grounds, factual grounds, legal grounds, based in the zoning bylaws and the design guidelines for the denial. One
Okay.
of those grounds is this allegation that there's a title issue with respect to one parcel. That ground has no basis in law. If any of these grounds are erroneous, I think this decision is suspect and needs to be remanded.
Sure, I get that. But what I do see in the findings is that there are three particular references to the zoning bylaws. One is as to what we were talking about, the models. Second was to the traffic. And then the third, which I don't know if you've discussed yet, but I imagine you will, is this issue of peer review funding. All I see here as it relates to the title issue is a one sentence that states, there are also outstanding concerns with the ownership of the property 12-110, which the applicant surveyor identified as owners unknown. Like, that seems to me just sort of a contextual issue as it relates to the overall deliberation by the planning board. But do you believe that the title issue is actually a standalone basis that the planning board denied the application?
Chair Hennessy, I didn't write these findings. One of the findings is that there was concern with the ownership of the property 12-110, which the applicant's surveyor identified as owners unknown. That is a finding.
Right.
I
But
agree,
wasn't
there's
it
no
true?
specific reference to a
Is it a-
design guideline, but it is a finding of the planning board.
But is that not is that an incorrect statement, at least as of May 19 of 2026? Like, were there no outstanding concerns with the ownership, or were there concerns?
So this is reflected in the record. At the beginning of the permitting of this project, we had what is known as an ALTA survey. An ALTA survey is performed for title purposes. We included the ALTA survey as one of the plans. The surveyor at that time had identified this title defect and simply labeled one of the parcels owners unknown. We explained to the planning board that this is an ALTA survey that was done for purposes of title, that the LLC had site control over all of the parcels pursuant to the purchase and sale agreement, and that any title defect would be resolved between the seller and the buyer in connection with the real estate transaction, which is what has transpired. If you'd like to know the details, the property was purchased out of receivership the receiver's deed had a scrivener's error in it that didn't reference this parcel.
Right, so just to, out of the abundance of trying to sort of keep this thing moving forward, I'm just trying to figure out, is this accurate? Like, at least as of the time frame that the planning board issued their decision on May 19, 2026.
So
The LLC did not own in fee those parcels.
we don't presently own it in fee. We're
Right.
not required to own in fee.
That's fine,
My
then we
point
can
is a
move
legal
forward.
error. It's a finding not based within the site plan review zoning bylaw and the design guidelines, and is an extraneous reason for denying site plan approval here. And because it's contained as a finding, I think it's perfectly appropriate to treat it as a finding and not to somehow dismiss it as some extemporaneous comment by the planning board. These
I'm
are the
not
planning board-
dismissing it, Attorney Brodsky. I'm just asking you to acknowledge that that's actually a true statement, that there were concerns about the ownership of this particular parcel.
All I can tell you is that the Alta survey that was performed, I don't even know the date of it, identified that parcel as owners unknown. I have no idea what the concerns are referenced in this rather vague statement. Again, far outside of the authority of the planning board in site plan review.
Okay, all right. You can continue.
And lastly, there's an allegation that the applicant refused to supply the funding necessary for peer review, which the board reasonably requested. I've not been presented with any invoice from Mr. Chesia that has not been paid. I have no idea what that refers to. I do know that at one point, we refused to pay for some particular peer review requested information, but I believe that all of Mr. Chesia's fees have been paid. And again, I don't think that's either factually correct or, again, a ground for denial.
What were the ones that the LLC refused to pay for?
In Mr. Chesia's original proposal, was a line item for review for zoning compliance. I wrote a letter to the planning board indicating that because the planning board is not the permit granting authority and had no authority with respect to zoning compliance, that Mr. Chesia should not provide that information and that we would not pay for that peer review. I believe at the end of the day, we paid all of Mr. Chesia's bills. I have not been presented with any bill that hasn't been paid. And so that's all I really can say on the issue.
And in your memo, you reference, it's paragraph 33. Actually, hold on, paragraph 36, that you reference. I'll just read the first sentence. It says, strangely, member Kleiman presented a motion to the planning board to engage independent legal counsel to challenge Mr. Kelly's zoning determination that the LLC's proposed building is a single building under the HCC, and that the LLC should pay for the planning board's legal counsel pursuant to the peer review regulations under this 410-4.1C3G. Now, that's a little bit different than what you're talking to me about, things that the LLC did not want to pay for. But are you lumping in this motion as it relates to getting counsel in with what the planning board may require from the LLC under 3G?
So all I can say, Chair Hennessy, is I have no idea what the planning board intended when it said and made the finding that the applicant refused to supply the funding necessary for peer review, which the board reasonably requested. If the planning board intended to take issue with our refusal to pay for a zoning compliance review by Mr. Chesia, I believe we actually paid for that despite the fact that we objected to that scope. If the planning board believes that it could legitimately ask the LLC to pay for, not for town council, for an independent lawyer to question the building commissioner's authority to make a zoning determination as a peer review, I don't think that's supported by your zoning bylaws at all.
All right, so
And I believe, and this is reflected in the record, that town council for the planning board rendered an opinion with respect to whether the planning board could do that, but I'll let town council speak to that if he wishes.
Sure, and just again, to try to track the chronology of all this, the preceding paragraph to 36 where you reference Planning Board Member Kleiman's motion to engage independent legal counsel, and you can tell me I'm wrong on this, but it sounds like based on the preceding paragraph 35, on April 22nd, 2026, the LLC and its team again presented the project changes to the planning board. Is it your position that that motion by Attorney Kleiman was made on April 22nd, 2026?
I'd have to grab my appeal. I have the date on that, and we do have specific quotes on that.
Okay. If you want, I don't want to marry you to words that you don't, or to statements that you don't know. So if you have a copy of
Sure.
your memo, just, it may be helpful.
Yes, sir, that motion was made on April 22, 2026.
Okay, and then just for everybody's education present tonight, both in person and on television, I'm going to just reference this section 3, so 410-4.1C 3G, and it states, it says, additional materials required. After initially reviewing the proposed site plan, the planning board may require that the applicant submit any of the following materials. Subsection G is, should the planning board find it necessary to seek advice or assistance, it has the authority to employ professional consultants or experts, including technicians, attorneys, engineers, and/or architects for the purposes of reviewing and evaluating on its behalf the information shown on the site plan and any additional material. Costs of such professional assistance incurred by the planning board shall be borne by the applicant. And then there's the caveat. However, the cost to be paid by the applicant shall not exceed the reasonable and usual charges by the consultants. That's 1. And 2, shall be estimated in writing by the consultants and made known to the applicant before the board incurs any costs. No occupancy permit may be issued by the building commissioner until the applicant has paid or reimbursed the town for all such costs. So with that mouthful, is it your position, the conditions here, the however sections, 1 and 2, is it your position that those were not satisfied by the planning board, either before or after planning board member Kleiman's motion on April 22nd, 2026?
So I agree, but our principal position is that that's not what was done here. This was not to seek outside advice regarding reviewing the project for compliance with the design guidelines. This was to see whether the planning board could challenge Commissioner Kelly's determination that the project complied with zoning, completely outside of the planning board's scope of authority under site plan review. So I don't think that that provision applies. I don't think that would be a legitimate request to an applicant for peer review. That was an attempt to fund some grudge against the building commissioner because they didn't like the zoning determination.
We have nothing before us tonight, Attorney Brodsky, that supports this concept which you've alluded to in your memo of a witch hunt or grudge or what have you.
So I respectfully disagree, sir, because there was extensive discussion regarding how the planning board has a problem with the building commissioner, disagrees with the building commissioner's zoning determinations, and this was going to be an opportunity for them to hire their own counsel, not town council, but hire their own counsel to take on Commissioner Kelly at my client's expense.
As it relates to the site plan review, and obviously this is not a judicial proceeding, so rules of evidence and hearsay and all those kind of things don't necessarily apply, but rather than you make those statements on behalf of the planning board, I think it's best to sort of, put those things to bed and allow the planning board to respond in due course. And the other question, as I was wondering, is if the discretionary information required by the planning board as it relates to site plan review, all articulated in, section C, 2, and 3, these are things that all are derivative of coming to some sort of outcome or determination on the site plan review, correct? That's?
No, sir.
Okay.
This was unrelated to site plan review. This was the planning board's beef with the building commissioner. I have a direct quote.
Okay, I'm gonna move
Can
I
that
have
you,
a
ask a
direct
clarifying-
quote, sir, a direct quote. So I'm, the direct quote from the former chair is that, quote, "This is a vote that we want outside counsel to determine this ruling by the building commissioner that this is one building," unquote.
is that,
The zoning
again,
determination.
again, you're assigning specific statements that are from somebody else, that, in all circumstances, that is something that would be thrown out from any discussion. But in an effort to just sort of
So I
eliminate.
disagree. This is a
just let me
statement of the
finish.
chair.
Let me just finish.
Yes, sir.
And this, there's no opportunity for cross-examination of anybody in this room. But what I'm saying to you is, it's simply, I just need this to know, it's simply your position that the planning board's inquiry and request for counsel to research, investigate, opine on the building commissioner's determination as to what this project is actually. It's your position that has nothing to do with the design, the site plan review bylaw process.
That's
Okay.
correct.
Then we can leave it
because-
at that. Then we can leave it at that. So proceed if you have anything further.
Again, as I indicated, it's our opinion that there's no question that the decision should be reversed. And as I mentioned, the zoning board of appeals can't grant site plan approval. And so the remedy here is to remand this back to the planning board. And for all of the reasons set forth in our appeal document, we have concerns that we would have a fair review of these issues with the planning board. And so it's my opinion that the planning board, while cannot specifically issue a decision, that it could put guardrails around the remand. And I proposed that those guardrails be the draft decision that was prepared by the planning board that we were prepared to discuss on May 14th, with the reasonable changes that were made by the LLC in response. Those conditions incorporated the conditions that were recommended by Mr. Chesia and some of our suggestions. And it's really, that should be what should be discussed on remand, and it's the only way to ensure a fair and impartial hearing on remand if the board so chooses. And I'm prepared to discuss that draft decision, which contains the planning board standard conditions, and as I mentioned, some special conditions that were prepared by the planning department that address some of the concerns of the planning board, some of the concerns of Mr. Chesia, and modified in minor respects by us, and I'm prepared to have that discussion with you at the appropriate time. That's contained as Exhibit 3. I have additional copies of that, which I'm happy to hand out. I don't know if you want to have that conversation now or later.
Not now. I just want to ask a couple questions about your memo. And it's relevant to kind of some of the issues that are somewhat inflammatory. It's like on paragraph 28 of your memo, you state on behalf of the LLC that on information and belief, the planning board purposefully delayed review of the site plan application, requested peer review services outside the scope of its authority, and made the review of the site plan application unnecessarily complicated in an effort to drive up the LLC's costs and discourage the LLC's effort to permit the project. Now, I'm a huge fan of the on information and belief because I see it every day in the stuff that I do. But do you actually have any solid evidence, either attached or exhibit otherwise, that supports your position that there was a purposeful, that the delay was purposely done by the planning board to frustrate the LLC's efforts to proceed?
So you'll also note that after the denial, we submitted extensive public records requests to the town. The town has not timely responded to that. We've recently just gotten a portion of those records. Some of those documents are very interested, but we have not received the lion's share of information. These are requests for communications between and by members of the planning board, members of the general public. Again, we did not have that information at the time that we were required to file our appeal, and that public records request is presently the subject of an appeal to the records division of the.
Understood. That again has nothing to do with what we're here for tonight. I'm just trying to determine that as of the date that you submitted this memo, June 16, 2026, like if there's, I mean, you include so very many exhibits as part of this appeal memo, but there's nothing as it relates to support, and I understand your position, but I'm just asking you to confirm that there's nothing in the record below or referenced in your memo that factually supports the statements made in paragraph 28.
So I respectfully disagree. I went through the chronology, the delay in opening the public hearing.
All within the
delay-
timeframes prescribed by the bylaws, though, correct?
Correct.
Okay.
The delay in obtaining Mr. Chessia's initial proposal, the concerns regarding the scope of that proposal, which were also addressed in
And
this
let me
letter.
just unpack that one. So I don't, are you referring, this is in paragraph 27. It says, notwithstanding, upon receipt of the Chessia Consulting proposal, the LLC provided the request of payment of $5,000 on or about March 5, 2026. However, the Chessia Consulting peer review report was not produced to the LLC until March 25 and provided to the LLC on March 26, well after the public hearing on March 18th. Is that what you're talking about? Like the delay of 3 weeks or so from March 5 to March 25?
Yes, what typically happens when you submit a plan for site plan review, staff reaches out immediately and receives proposal for peer review. I just remind you that we submitted this in January 2026, and so we're not seeing peer review until March. And then thereafter, it's just requests for additional information and trying to move this thing forward.
Got it.
As I said, as of the date that we were required to file this appeal, we had not received response to our public records request, which actually was filed
We
on the very
understand
same
that.
day.
I understand that to be true, but that, again, has no bearing on tonight.
Well, you asked me on what information and belief do we believe that? We have reason to believe, but you asked for proof.
It's
and
not referenced in the memo. So when it's not referenced in the memo.
timing is referenced in the memo.
Right, but the appeal of the
scope-
public records request, that has no bearing on tonight, nor is it referenced. So I'm gonna ask that we just sort of move this thing forward. I appreciate your explanation on what's stated here in paragraph 28, and I wanna move this thing forward. So if you go down further in paragraph 30, it states, on April 1, 2026, the planning board conducted a site visit of the property. Again, on information and belief, the site visit was not noticed as a public meeting, and the planning board allowed members of the public to attend and comment on the project. Now, before you respond to that, my question as it relates to this particular statement is, were you or any members of the LLC present on this April 1, 2026 planning board site visit?
I was not present, but members of the LLC were present.
Okay, all right. And then, as it relates to the suggestion that it was not noticed as a public meeting and that the planning board allowed members of the public to attend and comment on the project, where do you get confirmation of that? Would that be members of the LLC who were present at the site inspection?
So if you look at the agendas, it was never noticed as a public meeting. So you can look at the agendas relevant to this. The observations as to what occurred is directly from members of the LLC who.
Okay. And just, again, as I'm trying to educate myself, just as the whole public needs to be educated about this, and you can tell me if I've strayed, but I know that when we have ordinary vanilla applications that come before the ZBA, there is oftentimes a recommendation to the applicant that a site visit occur to better assist the board with, coming to some sort of, conclusion on an application. Those are not public meetings, and we've drilled down it being a very specific, eyes-only sort of review, and that nobody talks about anything when they're there. So is it your position that the planning board would have been required to notice this site visit as a public meeting, and that they did not do that?
If it wished to entertain public comment and wished to deliberate on the merits, it would have to be a public meeting. Otherwise, it's a violation of the open meeting law. We did not file an open meeting law complaint. We're in the middle of a permitting process. We're trying to get along with the planning board. We were not going to be filing an open meeting law complaint at that time.
Okay, and as it relates to that alleged violation of the open meeting laws, you yourself, Attorney Brodsky, did not observe any exchange of information between members of the planning board present on April 1st, 2026, and any of those from the public who were there. That's what's been relayed to you from the LLC, right?
And you can ask members of the LLC if you would like direct testimony on that issue. I
do
cannot
not
recall who attended.
Got it, okay. So that, it's your position that...
Mr. Fleck attended, and if you'd like to ask him those questions, he'll tell you what transpired.
Sure, yeah, please.
Prior to the meeting, the chair of the planning board also announced publicly that it is not a public meeting and discouraged the public from coming. And then the public came and asked, Pete was also there, asked questions continuously, and questions were entertained back and forth throughout the entire year of the meeting.
Okay, between members of the public and members of the LLC?
Correct.
Okay, and that your statement that the planning board, ahead of that meeting, declared that it was not a public meeting, but that because of these comments and exchange of information, you're saying that is why this would have or should have been a public hearing, properly noticed, et cetera. Is that correct?
Correct, and additionally, we've got the allegation that Member Kleiman asked about the status of an extension of the 105-day decision period, again, inviting actual deliberations by the planning board at an unnoticed public meeting.
Again, from
Direct interaction with me.
got it, okay, all right. Okay, anything else, Attorney Brodsky?
No, sir, we're happy to answer any questions. Again, I'm happy to discuss the proposed special conditions that we suggest that the zoning board require that the planning board consider on remand if you decide to reverse. Thank you.
Okay. All right, anybody from the board have any questions?
No.
Phil?
Just seems to me that there's a lot of nitpicking going on by Mr. Brodsky. You know, you're alluding that someone did this or someone did that. I just don't buy any of that.
Do you have a question, though?
No, I don't have any particular question.
Okay. And then, I guess, Attorney Brodsky, while you're still up there, I know you've, this is just one more thing I wanted to sort of get out in the open, and then I'll open it up to any other questions that the board may have. On paragraph 42 of your memo, it states, on May 14, 2026, the planning board failed to consider the LLC's request for a continuance and instead subsequently reviewed the matter without the LLC or its representatives present. Now, it's, and I think I know the answer to this question, but it's your position that the planning board's decision to either ignore and/or deny the LLC's request for a continuance, that was an improper,
An abuse of
Decision.
discretion.
okay, an abuse of, but it's discretion nonetheless.
I've already acknowledged that the planning board is not obligated to grant a continuance. All I can do is practice in the manner which I've always done in the town of Hull and rely on how things have happened in the past.
Okay. All right, anybody else, if you have any questions, you're more than welcome to ask them. Otherwise, we'll proceed with the planning board.
I'm all set.
Tony?
No, I don't have any questions. Do you know what time on the 14th you asked for a continuance? It was the day of the meeting, right?
I don't recall, sir. I mean, there was a conversation with the town planner that afternoon when the request was made, and we turned around we agreed to do so, and I turned around a letter as quickly as we could.
Okay, thank you.
And then I guess I'm sorry for not being through, but like the paragraph 53 of your memo, it states the decision itself, meaning the May 19 decision, fails to identify with any specificity the additional material information which the LLC allegedly failed to provide, except with respect to mention of a request for a model. So obviously, I understand that, and that was one of the independent bases to deny the project. But and we could get into the weeds about, this, 3G as to what a model represents based on, the LLC's testimony or what have you. But when you say the planning board's allegation is incorrect and misleading, is it because of the language of that bylaw section as it relates to model? And that it doesn't, as the LLC member, forgive me for not remembering your name, sir, but that it can be interpreted either in, like, what we're talking about here tonight, like something you put on a table and everybody sees everything, versus like a 3D rendering on a piece of paper. Is that what you're saying is incorrect and misleading?
Well, first of all, again, with the exception of the model, they did not specify what additional information was lacking for the grant of site plan approval. And again, I mean, the client's got hundreds of thousands of dollars invested in this permitting process. To somehow affirm a decision of the planning board because we've refused to provide a paper model seems to be, I think, contrary to the intent of the zoning bylaw.
I
But
get it.
yes, it's misleading in that we did provide sufficient information to depict what this project would look like in the context of the site and the neighborhood, so that the planning board could review the design and make a determination that it's consistent with what they're trying to achieve in that zoning district and that neighborhood.
And I guess the final question that I have, subject to anything further, is that if you were to look at, hold on here. So if we're talking about this subsection, C3, and then A through G, these are additional materials required, where the planning board may require the applicant submit. Is it your position that by basing a decision, among other things, on the failure of the LLC to provide a specific additional materials required, meaning just this section F that says a model at the same scale, is the planning board prohibited from denying an application or the site plan application based on one of these required materials, or is it your position that it has to be more than one? Meaning, like, can a denial stand on an applicant's failure to not submit any one of these items at the request of the planning board. And if I'm unclear, I apologize, but it's 9:10, so my words may be a little bit
So
fumbled.
your question to me is, under the Hull zoning bylaw, could the planning board deny site plan approval for a redevelopment of a project that's, of a property that's been underutilized for decades?
No,
Based upon
I'm just
one-
asking.
One omission, or one piece of information that was not provided under the bylaw? Is that your question?
Yeah, so like, for example, even removing it from a model, like say, for example, if the planning board required that the applicant submit conceptual drawings of buildings and structures to be erected, including elevations, the applicant did not submit those things, and as a result, the planning board denies on that single issue. Taking it further to this subsection F as it to the model, I'm just trying to get your position that if the planning board asks for one thing and that the applicant does not provide that one thing, that by itself is not enough to support a denial.
Correct. Again, you need to demonstrate conformance with the design guidelines. In fact, the board action section 4.15 says you may grant approval, may deny approval. And by the way, I stated in my preliminary remarks that despite what the bylaw says, the case law in Massachusetts dealing with site plan review makes it pretty clear that under site plan review, planning boards really don't have the ability to deny an allowed use. They have the ability to condition a use. But if you see that, and whether the proposed development is in conformance with the design guidelines. So if the planning board was going to say, we're going to deny the project because you failed to provide us with a physical model, they'd have to relate it to how that somehow rises to a level of a violation of the design guidelines. How the failure of that piece of information did not allow the planning board to address the design guidelines. It's a one-off piece of information, cherry-picking a section of the bylaw and without understanding the context of the bylaw. The bylaw is intended to review and condition projects to ensure compliance with the design guidelines. And I have no idea how the failure to provide a physical model somehow rises to the level of a failure to demonstrate compliance with the design guidelines.
Rich, I have a question.
Go ahead, Tony.
If I could, it was a unanimous decision to deny,
Yes, sir.
and that was based on insufficient information, incomplete submission, inconsistent materials, applicant's failure to appear, applicant's failure to provide required documentation, and the design review board's negative recommendation. Chair Paquin stated she would work with town council to prepare a formal written finding. Did you receive that? Did
Receive
town
what, sir?
council provide you with a formal
Sir.
written?
No. Again, we were not present. They voted to deny. There were not specific findings made at that hearing. I watched the videotape. And again, the procedural issue is that before you vote to either approve or deny anything, you need to state with specificity, particularly if you're going to deny relief, the specific reasons why. You typically would not file a decision with the town clerk until that decision is reviewed, those findings adopted, and the decision approved. In this case, that was all done outside of the public process. Doesn't require a public hearing, but should be done at a public meeting. That's as if, say, you voted to deny a special permit. You don't discuss the reasons for it, and then you draft a decision and just file it with the town clerk without reviewing the decision, without voting on the decision. I've never seen that done.
And then what you reference in your own, when you reference like what the bylaw states versus what, case law states, both the planning board and in your own memo, Attorney Brodsky, there's reference, and I'm not gonna, this isn't a Socratic method pop quiz on case law, but this Prudential Insurance Company of America versus Board of Appeals of Westwood, it's cited in everybody's, submissions, and there's, one one head note here that says, zoning board may lawfully reject site plan that fails to furnish adequate information on various considerations imposed by bylaws as conditions of approval of a plan. So I guess, without going into the weeds of how the appeals court came to this determination, it would probably be simple for you to just say is the planning board's, and this, I think this case may have corresponded to a zoning board decision, but that if we extend it to the planning board, if the planning board makes a request for a particular piece of information, this model issue, is it your position that that's not an adequate piece of information that functions to marry everything together? Meaning that I think I take it is that your position is that this is sort of like a anecdotal, sort of, as you say, I'm not putting words in your mouth, but basically selecting one of several things that the planning board may require of the applicant, and that because they're zeroing in on this one issue, you believe that that's inadequate as sort of a standalone basis.
Yes, I mean, prudential generally stands for the proposition is that you have to have some really, really, really good reason to deny site plan review. It's got to be a real substantive public safety issue or something like that. The failure to provide a model, I don't think, rises to the level of that test. And in fact, Prudential was in 1986, and I provided you with more recent case law that, again, makes it specific. The scope of site plan review, and I'm quoting Hudson Walker, which cites SCIT Inc. That's a 2025, again, land court decision, but I was looking for the most recent law, quoting SIT, which is an 84 case, is around that time. The scope of site plan review is thus limited to imposing reasonable terms and conditions on the proposed use, and the denial is not an option for the board. For your information, and again, you don't want to hear new information, the Attorney General's office rendered an opinion.
Therefore, I don't want to hear what you're saying
on this very issue
right now.
in 2025 in the town of Hull.
That's fine, but that's,
Okay.
so what I'm just trying to figure out is, like, nobody can deny that the planning board's decision makes reference to a specific piece of information that is included and articulated in the bylaws. They weren't asking for things that were not codified in the bylaw, correct?
No, sir.
Okay.
Again, as Mr. Flex said, it doesn't say that you need a physical model, you just need a model that shows these various elements. That's what you do with three-dimensional computer-generated modeling.
And is it your position that those, Mr. Fleck's position that the three-dimensional drawings, did those actually provide what the bylaw requires, meaning a model at the same scale as the site plan, showing the entire project and its relation to existing areas, building structures, and roads for a distance of 100 feet from the project boundaries? Is it your position that the 3D drawings that were submitted included and referenced this 100-foot distance from project boundaries?
All I can tell you, unless I stand corrected, is that the modeling was based upon the actual site plans and architectural plans to scale.
Okay.
As to what the land area is, I do not know.
Okay, so as you sit here, that you don't know the answer to that question, which is fine.
Right.
So, okay.
But again, I just want to leave the point of the modeling is to show what the building is going to look like in the context of the neighborhood. I don't think there's any doubt whatsoever, given the information that we provided, that we did not provide sufficient information to satisfy that requirement of the design guidelines. We're having a somewhat academic discussion regarding how you interpret an antiquated bylaw.
Got it. But a bylaw that's on the books nonetheless. And then
So if it's the board's position is that you have to apply the bylaw as drafted in all instances, regardless of the application of common sense, I don't think that's also a valid point.
okay.
We're not slaves to the zoning bylaw. none of the boards in the town are slaves to the zoning bylaw.
I think reference to the term slave is a little bit weird, but I also think, that absent anything else, the bylaws are the bylaws. The bylaws are what guide our decisions in ordinary garden variety applications before the ZBA, and they are what they are.
And the board has always, consistent with case law, reasonably interpreted your zoning bylaws to achieve the purposes of the zoning bylaw.
Right, the mission behind why we have these zoning bylaws. I understand that. And then, just the other part of the planning board's decision I wanted to talk about was, there's reference to the traffic studies or what have you, and there's reference to dangerous roadways conditions and failure to provide certain information as it relates to other areas of the bylaw. Are you, in your appeal tonight, are you discounting that component of the planning board's decision as not being reasonable or within the confines of their charge under the bylaws?
I don't think there's any finding that there are dangerous conditions that we didn't address. But let me review the findings once again.
I got a question.
Sure. Let him do his thing first.
Finds that the traffic conditions primarily at the intersection of Fitzpatrick Way and Nantasket Avenue will be negatively impacted and create a dangerous roadway condition. That is the finding. There's absolutely no factual basis for that conclusion. Qualified traffic engineers confirmed by the planning board's own peer review consultant confirmed that that's not the case.
All right, and let me just try to marry that to these particular bylaws that are cited by the planning board in its decision. The first one is 410-4.1D1C, and these are design guidelines. D1, the following specific items may be considered by the planning board in making its decision. And then when you go to C, it states convenience and safety of vehicular and pedestrian movement within the site, the location of driveway openings, and in relation to traffic or to adjacent streets. And the second one they refer to is 410-4.1D2D, which states, number 2, in considering these items, the planning board should use the following principles. And then when you go down to D, drives, parking, and circulation. With respect to vehicular and pedestrian circulation, including walkways, interior drives, and parking, special attention shall be given to location and number of access points, general interior circulation, separation of pedestrian and vehicular traffic, and arrangement of parking areas that are safe and convenient, and insofar as practicable, do not detract from the design of proposed buildings and structures and the neighboring properties. Landscaping and/or fencing shall be used to buffer parking areas from adjacent areas. Pedestrian access to nearby public areas such as parks, beaches, public buildings, and structures, and commercial establishments shall not be impeded, but rather encouraged whenever possible, and barriers to pedestrian patterns shall be avoided. Now, those are the two specific bylaws that are cited in their findings. And what I'm wondering, Attorney Brodsky, and please point me to this, but is there any requirement in the bylaws that the planning board are obligated to, regardless of whether or not this is, conventional common sense, but is there anything in the bylaw that states that the planning board is required to make reference to a particular traffic study or transportation memo or what have you?
Sure.
Or can they simply interpret these bylaws in the, with the goal of putting the essence of the bylaws in place without having to refer to some professional secondary report?
No, sir. The planning board has to justify its finding with specific reference to facts to support that finding. It can't make an ambiguous conclusory statement, oh, the intersection is dangerous. It has to articulate why it's dangerous, upon how did it derive or create that conclusion. And that's got to be reflected in detailed findings. How else could a court or a board reviewing the decision make a determination that there's factual support for that finding if that information is not in there? And that's what often happens in a court. The court will remand it to a board to ask for additional information. Well, why did you make this conclusory statement? Where is the evidence that supports this? We've presented to you actually only evidence by qualified traffic professionals in the context of that review that proves the exact opposite.
Okay. And so I understand, like, if in this particular paragraph of the findings, if it was only, the board also finds that the traffic condition primarily at the intersection of Fitzpatrick Way and Nantasket Avenue will be negatively impacted and create a dangerous roadway condition. If that was the only thing that was included in there, I would be more supportive of your position. And this is for just a discussion here. But there's more. Like, so in this decision, it states that the Nantasket Avenue roadway is becoming one-way along the new seawall. The number of vehicles traveling southbound on Fitzpatrick Way and making a left turn onto Nantasket Avenue directly adjacent to this site will increase, as this will become the only access point.
Based on what, though?
No, I
guess
understand that.
My concern
Right,
is
so,
that,
yeah, let me just complete my thought here. The proposed building is further north than the existing buildings on the site, and the corner of the new building along with the exterior stairway would impact sight lines for these vehicles making left turns onto Nantasket Avenue and Allerton Hill. And then it concludes that the applicant has therefore failed to provide sufficient information to demonstrate to the board's satisfaction that the project complies with those two particular bylaws. My question to you, Attorney Brodsky, is this information that sort of, supports the general statement of it creating a dangerous roadway condition, is it your position that the planning board is not qualified to make those statements without having some reference to something else, like either a factual, like some fact in the record, some document in the record, that these statements, naked as they are, were inappropriately included in this decision by the planning board?
Mr. Carlos, do you want to speak, or Chris?
Can I speak? Yeah.
Oh, please.
Thanks.
They did
So we paid
And who are you?
Chris Reel. I'm an attorney, also an owner of New Point Nantasket Realty.
Sure.
Traffic impact study.
The town hired a peer reviewer, John Chesia. We paid him twice. That was what was referred to. He provided in his most recent memo the following statement. This is all we had to go by. Carlos responded.
What's the date of that memo?
That
Is that the
was
one that was submitted by Attorney Brodsky on May 14 or May 12?
No, this is the peer review report submitted by John Chesia.
Okay.
May 12th.
May 12th, also May 12th.
And so Carlos responded with his supplemental traffic memo on May 12th as well that he referred to. Mr. Chesia's report stated the following. A transportation memorandum has been submitted that primarily addresses site distances. I note that site distances should be based on the 85th percentile of measured speeds, not posted speeds. He then crossed out a bunch of information because we'd already provided it. And he said, on-street parking has been eliminated. Site distance should be based on the 85th percentile speeds, not posted speeds, and the site distance lines should be identified on the plans. If deemed appropriate, the board could include this as a condition if the project is approved, as it appears that site distance, even for faster than posted speeds, could be provided subject to potential impacts from the proposed monument sign and landscaping. So as the applicant, as somebody who's responding, that is the only basis that we had to go on heading into May 14th. When we requested a continuance, it was based on a few issues that Mr. Chesia had noted. They were all fashioned as conditions. Mr. Diorio, the planning director, included all of his recommendations in the decision. Out of respect for the board, who had not seen that decision yet, and out of respect for our time, and we already relayed this whole timeline. So the idea that this is nitpicking is frankly offensive.
Well, okay.
And
I'm gonna
let
ask
me
you the
just
whole
finish
thing.
what I'm saying, if you don't
Absolutely
mind.
not. So what you're doing right now, Mr. Reel, is sort of, nobody's answering my question. I simply
Why am I
want.
not answering your question?
Because so what I'm just trying to ask of either you, Attorney Brodsky, or you, is the statements made by the planning board in their findings in this paragraph. Is it the LLC's position that those statements are inappropriate simply because they do not make reference to any reports themselves. That's all I'm trying to
Yes,
figure
the
out.
only report we
That's all
have
I need.
is what Mr. Chesia provided. If he
That's all.
provided them something else to form that basis of opinion, we were not provided it.
Okay, that's all I wanted to know. So I'm grateful for your comments, but I don't need anything further from you.
And I want to note, in connection with that, that these statements are in contradiction to their own chosen peer review.
And when you
And
say
so
to their own,
The planning board's own peer review.
Okay.
So that's important, I think, in the context of understanding whether these are an appropriate finding
Okay.
or not.
All right, then LLC, anything further? Can we
Yes,
go to-
actually, yes, we do have something further. So this is the final timeline that we had.
This is already discussed.
No,
so-
I haven't discussed this yet. This is a slide we haven't shown
New
yet.
discussion.
We'll make the night a lot easier for you if you let me finish, if you don't mind. So
You don't need
was-
to make my night more easy.
Oh, no, I just,
So please refrain from that kind of commentary because it has no bearing on
okay,
what
well,
we're doing.
if I could just say what I'm gonna say, that would
Is
be
this,
great.
is this already in the record? We know when these
Yeah,
hearings
this is a
occur.
transcript. This is from the planning board.
Then that's fine, we
Comments.
have that, so you need not make reference to it because it's already in the record. So I appreciate your time.
Chair Hennessy, you don't have a transcript? All are available are videos. These are transcriptions of portions of those hearings. So
And-
unless the board is going to watch all of the videos, it might be helpful to actually see the statements.
We see the statements, they're in your slide deck, and I'm certain that the planning board will address those statements without the need for extra airtime. So I'm fine with having the planning board address the timeline issues, but I do not see the need for you to sort of regurgitate what's on a slide that can be addressed by the planning board. That's my position, and I'll ask that you sit down.
Could we just confer with our council for a minute before the planning board presents?
1
What do you
minute.
say? What's
Just
a-
1 minute.
1 minute.
I think it would be helpful for the timeline.
Yeah, what's he here for?
I think you'll have a chance for rebuttal.
Yeah.
So
We-
I think
I just have
would
one legal
recommend letting
question,
the
if you
planning
don't
board
mind.
move forward, and then
No, we're
you'll
gonna-
have a chance to respond.
We're gonna proceed with the planning
Yeah, you do it
board's
anyhow.
response.
Don't do that anyhow.
And I'll ask that you cease what you're doing right now, gentlemen. Gentlemen, I've asked you respectfully. You can hold this until after the planning board completes their response to this, okay? Okay. All right, before we go to the planning board, any questions by the board as it relates to the information provided by the LLC?
No.
That Chesney report that was on the 12th of May, is that a formal traffic impact study, or that's his summation of the conditions?
So I'll address that. So the Chesia report, that's the town's peer reviewer. He reviewed our traffic memorandum, and he provided his commentary based on the information we provided. The excerpt that was read back effectively reviewed our traffic memorandum and said, we agree that regardless of all the conversations, this intersection likely will not be a problem. I think that's the problem that we have with the planning board's decision, is that their decision comes to the opposite conclusion of both our professional traffic engineer and the town's own peer review. I think that's where the issue stands.
You want to go ahead?
So the traffic memorandum, if a physical traffic study was done, it would state the amount of traffic that went through, the speed, the safety, and all of that. The memorandum doesn't touch on that.
The memorandum evaluated exactly what was asked, which was to evaluate the sight line at that intersection to confirm that at the speeds, the sight line and the traffic and a stopped vehicle at that intersection would have sufficient distance to stop, to be able to account for turning movements at that intersection. That's what was analyzed
In the supplement.
in the supplement, correct?
Did the
In the-
planning board ask for a physical traffic study?
No.
No, sir.
Okay. And I guess just to sort of drill this point home, is it, and I'm directing this to you, Attorney Brodsky, is it your position that the planning board, within the confines of the site plan bylaws, that the planning board has no discretion in making their own observations independent of any formal report as it relates to traffic.
So any board can reject expert testimony, but in doing so, they have to explain why they're rejecting that expert testimony.
Okay, and it's, all right, so it's your position that in that section of the decision where there's reference to concerns about traffic and specific examples, is that that's not enough? Like, there has to be.
No, sir, those are just generalized statements,
Okay.
some of which I have no idea whether they're true or not, but they're not supported by any evidence. They're conclusory. And I should also mention, not discussed at the time that they voted to deny the project.
Okay.
That these are crafted afterwards, outside of the public hearing process, and never reviewed or affirmed by the planning board. And so that's why the decision itself is problematic and subject to reversal, putting aside the substance of it.
Okay.
But they basically should say, yeah, we don't believe the traffic engineers or Mr. Chesser for the following reasons, and that's why we reject the testimony. But they don't say that. They just provide generalized statements which I don't understand and can't tell you whether are true or not.
The planning board has a right to demand a traffic impact study if they can't determine if the situation is safe. It's one of the 3 criteria.
Yes, sir, and that was not asked.
That was discussed at that meeting. I was at that meeting. The safety of that intersection was
I
discussed.
don't know which meeting, sir.
The meeting
Meet
that you
the
were not
planning-
at, I was there also.
So if the planning board wanted us to do a more detailed traffic study, they need to tell us that
Right.
before they deny the project. Right. There's some element of fairness to this public process. And we've demonstrated our good faith. They never told us during any of the public hearings or through their staff that, no, what we provided was inadequate and we wanted more specific information. And as I said, these generalized statements, I think, were a pretext for denying the project.
And just, again, going back to like this review process, so I think this is C4, and I may be getting that wrong, but the review process includes all sorts of different things which we've discussed. But that subsection 4D states, in reviewing the impacts of a proposed development, the planning board shall consider the information presented in the application for site plan approval, all reports of town departments submitted to the planning board, and any additional information available to the planning board, submitted to the planning board by any person, official, or agency acquired by the planning board on its own initiative or research. And now, this is maybe getting a little bit too granular, but that seems to me to provide a runway for the planning board to do what this states, its own initiative or research. And is it your position that even in light of this review process subsection, that what's included in this decision fails to satisfy the review process criteria? And if I'm misinterpreting this, that's
So
totally
Can
understandable.
you direct me again to the section? I'm
Yep.
having a hard
Yeah.
time following the references. You're talking about the site plan review regulations.
Yep,
at
site
410,
plan reviews,
4.1.
and it's, I don't know if it's attached to C or what have you, hold on here. Yeah, it's C4, so it's C4, the review process, and this includes C4A through D. And then I'm referencing specifically 4D that talks about what the planning board may consider to include what I believe to be an option for them to conduct their own research or own initiative, as the bylaw states.
So Chair Hennessy, it says that in the bylaw. Traffic safety is not something of general knowledge, which is why we rely upon traffic engineers. If you're suggesting that the planning board could Google traffic safety and rely upon that as reliable scientific information on its own initiative, I would say that that's not an appropriate basis for information.
Okay.
Technical testimony provided by experts is necessary to evaluate traffic safety.
Got it. And what we have before the planning board is that technical information.
Yes.
Right? And then we have a review process criteria that allows them to consider and review any additional information available. So it's not site-specific, but I don't see anywhere, and this is just sort of splitting hairs, but I don't see anywhere in this review process that removes the option of the planning board members with their own background, experience, what have you, from making their own conclusions, like through initiative or research.
So again, Chair Hennessy, I'm going to respectfully disagree. I've litigated any number of zoning appeals, predominantly in the land and superior courts. And I can recite to you what I believe to be the case law, which is that if a board member is going to reject expert testimony, there's got to be a factual basis articulated in order to do that. Just like, oh, we just don't believe you.
Right. And what I'm just saying is that
And in this case, the planning board did not say that.
I'm just making it clear is that if we're, just like anything else, we're charged with taking these bylaws as it relates to site plan review and applying it to the decision that has brought us here tonight. And I don't see anything in the bylaws that says what you state, but I recognize what and it's not a humble brag on your part, because we know you litigate these things, but that a court may find that, that particular issue is not part of what the planning board should do. I'm just saying that the bylaws, as it relates to the review of all these things, does not prohibit or limit the planning board from making their own conclusions outside of the confines of some formal expert report. That's all I'm asking.
Again, sir, it's the reliability of the information which is critical and is missing from your analysis.
Okay.
Are you going to have lay people drawing conclusions from aerial photographs and testifying as to what those mean? I mean, it's the same problem.
We could do metaphors, analogies, whatever you want to do all day long, but I'm just saying that the planning board, their background, who knows what they have by way of background, but I will welcome commentary by the planning board as it relates to that issue, to reconcile this disagreement. So, again, we are 9:45 here, and I want to give people the right to go to bed at some point tonight. And with that, I would like to proceed with the planning board's presentation, if that's okay.
Chair Hennessy, could we take a 2-minute nature break,
Oh,
please?
yeah, for sure. Everybody, how about this? I have no problem.
It gets continued. Do you have a problem with that? Just maybe now's the time to bring it up. I'm sorry, I didn't mean to be overheard. I'm speaking too loudly.
No,
I was just gonna ask the chair and vice chair if they had any objection to it being continued, coming back. I don't know where the board's going with this and how late the board wanted to go, but just in case the question came up, I just wanted to know how the board felt about it, or the representatives of the board.
well, again, I'm mindful of everybody's bladder, both here and on the television screen. So if there needs to be a brief timeout for everybody to visit the commode, wherever that may be in this area, that's fine. We can pause this, and then if there is, I mean, I have no problem proceeding as far as we can tonight, but I'm mindful of the time, and I wanted to give both sides ample opportunity to present the good and bad and the ugly about each other's respective positions. So I can only imagine that the similar time frame provided to the LLC, I would want the planning board to have as well. So I mean, I don't know, council, if this is an issue that obviously, it's a two-part process, right? Like, LLC needs to agree to that. So if we want to take a break to pause and discuss?
Or if you have any idea of how long, if you think time frame of response? I know that's kind of maybe a hard question to answer.
Next time, I'm not gonna remember everything.
If I may, Mr. Chairman, and through you as well, counsel, Megan, you wanted to address the board very briefly on that point, and then I have a comment on it as well.
Is the question regarding whether or not we are willing to continue tonight?
Yeah, and-
Yes. We,
And to be able to respond to a lot of what we've heard tonight.
Yes.
Just a point for the record, the planning board is meeting tomorrow. I don't have a quorum of the planning board here, just for operational reasons. We didn't post a meeting, and I didn't want the board to be present with a full quorum for those reasons and others. But we certainly want a fair opportunity to make our presentation. We heard a lot of things tonight as well that we'd like an opportunity to respond to. And to do that adequately, I think I need to take it back to the board. I can't ask just the chair and vice chair solely to take responsibility on behalf of the entire planning board. So we can proceed to the extent the zoning board would like us to on what we have for tonight. But I think we would appreciate an opportunity to have the meeting tomorrow that's already scheduled so that we can fully and fairly respond to some of the things that we've heard tonight.
All right, and how about this? I'll suggest that we take like a 5-minute break for those who need to use the restroom, what have you, and absent counsel telling me that this is inappropriate, if the attorneys for both the LLC and the planning board want to hash out some proposal, because I don't want to compel you to continue this unless there is an agreement amongst all sides. So how about we hold this in, what's the term, like just pause?
Recess.
Recess. Yeah, recess for like, what are we, 10 minutes? Sound good? 5 minutes, all right, so we will hold this at recess for 5 minutes.
It's gonna take 5 minutes.